Perfect. So, I'm Liz Johnson. Jim and I were invited to speak on an exploration in alternative protective arrangements for guardianship and conservatorship. I guess Amy did our introductions, so we can move on to today's mission. Our hope is to go over what is considered capacity, and there's a three-pronged test for guardianship and conservatorship, and there are alternatives that should be considered before we file a guardianship or a conservatorship. The statute did recently change, and so there's a little bit of a blend of learning this new way that guardianships are happening. Jim and I are both court visitors, so we also get appointed as respondent attorneys. So we're always looking for ways to not involve people in the court system and to leave them the most rights as possible. So when you're looking at alternatives to guardianship and conservatorship, the first thing to understand is that the adult is presumed to have capacity until a court orders otherwise. So sometimes when Jim and I go out as a court visitor, we get a respondent attorney appointed and they can execute a power of attorney. Not everyone likes this because they feel like the filing of the guardianship petition stops them from being able to do it. But until the court orders that they're not able to do it, they can do it. Incapacity should not be assumed just because someone has Alzheimer's or dementia or Down syndrome or any other cognitive impairment, autism, memory loss, a TBI, or even a developmental delay. Washington has a low bar for capacity for estate planning, and so we don't want to put people into the court system that don't belong there. So when we're looking at capacity, which is not explicitly defined, you establish legal capacity. The client should demonstrate an understanding of the nature and purpose of the power of attorney. They should comprehend the authority that they're granting to someone else and how that might impact their legal rights. And they should have the ability to evaluate the consequences of granting such authority, and then how that is demonstrated is up to the attorney. If power of attorney, if we're looking at power of attorney or guardianship or conservatorship, there is a three-pronged test. So the court has to find that the respondent lacks the ability to meet essential requirements for physical health, safety, or self-care because the respondent is unable to receive and evaluate information or make or communicate those decisions, even with appropriate supportive services, technology, or supported decision-making. So that one actually probably comes up the most when people file a guardianship. We can usually get there, but the next two become the challenge. Appointment also has to be necessary to prevent the risk of significant harm to the adult through their physical health, safety, self-care. And what gets confusing about this is risk is a big word. I mean, we're all at risk of being financially exploited or harmed in some fashion. It can't be a potential, but without any teeth to it, risk. Obviously, somebody with a developmental delay or a cognitive impairment could be financially exploited, but if they live at home with their parents and they're never with anyone who isn't a trusted person for them, then the risk is more theoretical than practical. So that is one where when I'm working with parents, they'll say, but she has autism or she can't talk. Somebody could trick her into signing something. It's very different if we have somebody already in play who is trying to trick them presently, like we have somebody in their life who is trying to get them to sign documents or is taking out credit cards in their name. But the mere idea that it could happen is not enough to create a risk. The respondent's identified needs cannot be met by a protective arrangement instead of a guardianship or other less restrictive alternative. So if they have a power of attorney, or if all they have is Social Security and they have a representative payee, then they don't necessarily need a conservatorship. There are alternatives to doing the guardianship or conservatorship. But all three of those things have to be found together. And guardianship is not proactive, it's reactive. Anybody could be exploited at any time, but we can't do guardianships and conservatorships based on that.
All right. So let's assume we meet prong 1 and prong 2. Let's talk about prong 3. And I'm just going to say one thing about prong 2. This is the one that I have the most issue with. Simply having autism or simply having dementia does not meet a significant risk of harm. There has to be demonstrated harm. So what I kind of joke about is if there's, as Ms. Johnson said, if there's an ability to take advantage of them, well, we all could be taken advantage of. If they're running down the street, Pacific Avenue naked, that probably is a significant risk of harm. So you've got to look at that. And that's the thing I see in most petitions that get kind of gets overlooked. They're disabled, so we get a guardianship, but it's really a 3-prong test. So now let's go into less restrictive alternative. 11-130-010 defines a lesser restrictive alternative as an approach to meeting an individual's needs which restrict fewer rights of the individual than would be the appointment of a guardian and conservator. The term includes supported decision-making, appropriate technological assistance, appointment of a representative payee, we'll talk about that in a second, appointment of an agent under a power of attorney for healthcare or finances. Supported decision-making is assistance from one or more person of the individual's choosing in understanding the nature and consequences of their decisions. So what we see a lot with disabled individuals is they have the ability to understand certain things, but maybe not understand the more complex matters. It's one thing when you have the 18-year-old with autism who can say, yeah, I want mama to help me make healthcare decisions. I want mama to help me with my financial decisions. The second big problem I see in petitions is people who petition for a guardianship and a conservatorship, and we didn't break the difference down between those. A guardianship is what used to be guardian of the person, healthcare decisions, placement, things like that. Conservatorship is the money side of things. One of my frustrations with guardianship petitions is you see petitions where there is absolutely nothing about money that applies, and there's a representative payee. Well, that's already a lesser restrictive alternative. We do not now need a conservatorship to deal with that. It's so weird for me to see a petition that maybe should be guardianship only, and maybe that's valid, but then they throw conservator because they're worried about other money. They may get a job in the future. Well, again, that's not a significant risk of harm. This is reactive, not proactive. So be aware of that. All right. What are our lesser restrictive alternatives? Well, the big ones are powers of attorney, limited power of attorney, durable power of attorney, and irrevocable power of attorney. I will admit I've not done an irrevocable power of attorney in this matter. I know other people who have. We do have things like trusts, revocable, irrevocable, D4A special needs trust, D4C pool trust, which includes the Arc of Washington DD trust, and an ABLE account. The other one I would put on here is, as I said before, naming a representative payee. I recently, over the last year, have had 2 cases where we had a conservatorship only situation. The only money this person had was Social Security, and they already had a rep payee. So why is there even need for a conservatorship? So that conservatorship was removed, and we just let them operate in the representative payee. Now, there are some potential problems using powers of attorney. And there is one specific problem that I worry about the most, especially I deal a lot with children with autism, which is they go, I'm going to date myself here because this is an old story, but they go to the mall, they're walking around the mall, they go to those kiosks in the center of the mall, and they sign up for aluminum siding for a house they don't have. So that is a concern. Because a power of attorney, as you should know, is something that is supplemental. It is not in any way, shape, revoking rights. So sometimes maybe it's worth doing a limited conservatorship simply to revoke the right to contract. I did a power of attorney recently where I put in the right to freeze credit so that the young woman would not have the ability to go out and sign for those things because she'll have, frozen credit. So those are things to think about. Just to explain a little bit more, let's talk about the D4A, the D4C, and the ABLE account. First off, special needs trust is not a thing. It is a term that's used to describe a lot of things. For our discussion today, what we're talking about is a D4A special needs trust, which is authorized by 42 U.S. Code 1396 PD4A, which is where it comes from. It has to be created before somebody turns 65. They have to be disabled, and here is the big one. It has to have a payback provision, so any money left in that trust when the individual dies goes back to the state. It can be established by the individual, a parent, a guardian, a grandparent, the court. When I first started practicing, the individual could not do it, and he had to have one of these other people, and luckily that law has changed in the last, it's probably 15 years ago because time flies. Related to the D4A is the D4C. It is a pooled trust. No, this is not putting your pool in a trust. This is basically a D4A trust, but it's administered by a nonprofit organization. Payback is required, but there often is an option to leave the money in the pooled trust for other disabled parties to use. So it's better than going back to the big bad state. It gets used by other disabled parties. As I said, ARCA Washington has a pooled trust, which I think they call the DD Disability Trust. ABLE accounts are something new that are amazingly awesome. Basically, I kind of refer to it as a disability version of 529 plan. You can put up to $100,000 in it for Social Security purposes. You can actually have more in it, but then it becomes a Social Security asset. You can only put up to $18,000 per year, the annual exclusion amount, you can look them at any state you want. Ours in Washington is called Washington Stable or Washington State ABLE account. You can do them in other states. You do have to be disabled before a certain age, but that is changing shortly. It's 26, and I don't remember when it is changing, but that's going to be an issue in the near future. One of the problems with these accounts is, well, not really a problem. What these are awesome for, and it's not related to what we're doing today, but when grandma puts, a $15,000 distribution to the disabled grandchild in the will without talking to the parents, you now have a child who's on benefits. The ABLE will allow you to move the money over there in order to have a situation where it is not going to count against their benefits. My other place, also not related, that I love it gets used for is Social Security is awesome. They'll delay and delay and delay, and then they'll give you your back benefit, and then they'll say, oh, you have $18,000. You now no longer qualify for Social Security. Well, you can bop it over into an ABLE account, and now they're magically okay. So that's some of the lesser restrictive alternatives. Now flipping, and by the way, the ABLE can only hold cash. It cannot hold investment. It cannot hold a car. It cannot hold property. Now, what about some lesser known, lesser restrictive alternatives? Say that 3 times fast. One of them is supported decision making, which requires an adult with a disability. It must be voluntary, and it must provide supported decision making for assistance in understanding options, responsibilities, and consequences of decisions. So let's use this if we've got somebody who's an addict who understands things, but maybe they don't really understand their consequences. We can have somebody who is named to assist the adult in accessing, collecting, retaining information, assist the adult in communicating that information. It should outline the terms of authority, and it does need to be in writing, signed voluntarily, and of course it needs to be dated. So where I would look at these is where you have somebody who's right on the edge of understanding, but they need some help. So they appoint somebody to make them make decisions. So let's go to the next one. So I am disabled in one part of my life. I make bad decisions when it comes to marriage. So I would like to do a supported decision-making agreement that takes away my right to marry. That's the only right we're going to revoke. So we've got an example here. I, James Bates, make an agreement of my own free will. I agree and designate Liz Johnson as my supporter. My supporter may help me make everyday life decisions, and I should have put in here getting married. So we would go to the final box and do the yes, other matters. The supporter is not allowed to make decisions for me, but they're able to help me with my decisions. So again, as I said before, access, collect, obtain information, understand my options, help me communicate my decisions. So in my exceedingly bogus example, Liz could meet my, future wife, say, you're an idiot. This is another bad choice. You're just going down the same road you've gone before. Let's evaluate this. Let's talk about this. And let's make this talk about why we can make decisions. She can't make the decision for me, but she can help me evaluate the information. Now that I'm talking about this, I'm thinking this maybe should be standard practice for every marriage that you go through this. Switching to the next page, this is the second page of the decision-making agreement. We sign this. It will continue until November 2nd, so I'm going to be free November 3rd. I'm going to get on all the dating apps and try to find a new spouse. And we signed it the first day of May. I have signed it. Liz is my supporter. I'm the supported adult. We've got a couple witnesses. Next page, we've got a notary, which is actually, you can just see on the bottom. You can do witnesses or a notary. The other thing is there is some language that needs to be included in it, and that is on this slide. I'm not going to read it because you're all able to be literate and read this stuff, but include that in your supported decision-making agreement. Yeah.
This last one that you're speaking of, I think it implies a great deal of contact regular contact between the person who signed the agreement and the person who's helping.
I would agree. The one I did was for a I forget how old he was, 20-some-year-old, and he named a family member that he had quite a bit of contact with. What his struggle with is he was 20-something, but he kind of acted more like a teenager in that he'd get mad at mom or get mad at dad and want to go live at the other one if, they wouldn't let him spend his money on whatever. So he named another party to help that. But yes, I think it absolutely does require, if you're going to be the supporter, I think you need to be available to the individual. And I think if you're agreeing to be a supporter, that is something you need to look at, because different people's disabilities act out in different ways. I met with somebody who was supposed to, there was some talk of doing a guardianship for this gentleman. And the problem with him is he just didn't want to talk to people. He just didn't want to meet with anybody. Well, I finally got him to talk to me, and there is no question in my head he does not meet the requirements for a guardianship. We were able to do some lesser restrictive alternatives, but if he could do this and somebody would help him out, he might be a really good person to have, dad sit down with him and say, here are your options. Here is the consequence of this decision, consequence of this decision. I don't think it needs to be somebody who lives with them, but I think it needs to be somebody who has a lot of contact with them. And the really nice thing in 2024 is we've all got phones. We can do video chats with anybody anytime we want. So that makes it really, really, really easy to keep in touch with people. In fact, the 11130 allows the guardian to visit via Zoom at this point, or electronic means, and it used to have to be in person. So there is certainly some ability to help people out. What I think this other protective agreement for is people on the higher end of the capacity spectrum who still have some issues making choices. I hate to say anything bad about my daughter because she's awesome, but she's 19, she has autism, and making decisions for her is very hard. And that is including what movie I'm going to watch, where we're going to go to dinner. So she might be somebody who would be really good with this because she can sit down and kind of talk through the decisions. It probably wouldn't look the same as if you or I were talking through decisions, but I think with some assistance, she can make decisions. I think what she was worried about, honestly, I think it's all FOMO, is, well, if I choose cheeseburgers, I can't have pizza. So maybe we'll have pizza next week, or we'll do something like that. And I know that's a silly example, but that's one that always comes to mind, because 90% of the words out of my daughter's mouth, if you ask her a question, is I don't know. And it's not she doesn't know. That's an easy answer to get a response that she can get out quickly. And it's really interesting to ask, where are we going to dinner? And that sometimes becomes a bigger decision. Where are we going to dinner tonight? What are we doing for dinner tomorrow? So that's kind of how I would look at the supportive decision-making agreement. Of course, I've used it for kind of silly reasons. But I think it kind of illustrates the value of doing this and allowing people to make their decisions and still giving them agency while giving them some backup to allow them to have somebody maybe who in theory has better decision-making ability. Though I'm starting to wonder, if you take this in a more holistic approach, you can take a lot of us and say, you're disabled because of this reason, not making fun of disabilities. But like one of the things I've heard in the past, people would do court visitor appointments and look in people's cupboards or look at how the house was kept up. Well, just because you're a bad housekeeper doesn't mean you're disabled. It may be a factor, but it doesn't mean you are disabled. Because you're eccentric doesn't mean you're disabled. Because you have a diagnosis of dementia doesn't mean you're disabled. So what I'm going to do now is I'm going to turn it back.
One thing about that same agreement. What do you think about two people each having that agreement? In other words, two assistants.
I think that's a great idea. I think I think all the support you can give somebody who has trouble making decisions, the better.
Right.
The statute, and I would have to dig in to see if the statute says anything about agents, but often when I name multiple agents, like in a power of attorney, I make them, joint and severally liable. In this case, I might try to write it such that they can consult either one of them, whichever one they want to, or both. Because I think that would be a useful tool. So I will turn it back to...
Hold on. I wanted to touch on that supported decision-making and the amount of time. I think it depends on what they need help with. If you're talking about somebody who is severely disabled, then you're probably looking at a parent, because one of the downsides to the other protective arrangements is a guardian can get fees if the person is receiving participation. It's not always often that... people are wealthy, so Usually you're looking at county pay cases. So if you have to appoint a third party, a supported decision making thing may not work because how will the third party get paid?
Yeah.
But it could also just be that they need help at more complex doctor's appointments. Like maybe they can make decisions about their day to day care, but maybe they have to have a very intense procedure with a lot of consequences. And that's where they maybe need a supported decision maker. So you wouldn't have to be as involved. You would just have to be involved for that procedure.
Thank you.
And honestly, I will joke, I kind of shut down when I go to the doctor. So I think that would be a helpful thing for a lot of us. I think understanding complex medical decision making is really interesting. And this is totally off topic, and then I'll turn it back to Liz. But there are some cool videos. Maybe cool isn't the right word. There's some videos out there on the internet of somebody sitting down with and I think they're all acted out, but sitting out with a medical professional. Medical professional explains the medication, and then they go out the room and they ask them, what did they just tell them? And it is often so off base of what they've said. The one thing that Liz and I haven't said is when you are applying for a guardianship or conservatorship, one of the things you need to be aware of is by signing the petition, you could be responsible for fees of the whole guardianship if you bring this and it's not a proper guardianship. I don't see that much. I see a lot that hovers around the closeness of they shouldn't be bringing it. They should have done some due diligence. But you also see situations where the family comes out of the woodwork and presents the power of attorney after just ignoring everything. So it's not, sometimes a guardianship needs to be brought to get people moving, but you've got to be very careful when you sign that. Are you putting yourself at some liability because really this person doesn't need it? And I will then, after this, shut up. Honestly, it's interesting to watch in the autism world, the people who are very severely affected by autism may be the people who don't need the guardianship because, as was said before, they either can't get out of bed or they're always going with mom, dad, or a caregiver. Well, what's the ability to take advantage of them? Where it's the people who are more active in the community and maybe less disabled who may need it way more because they're out doing things in the world and are a little bit more ripe for exploitation. So I think that's something else to keep in mind as well, is there is no one size fits all. Be careful when you're doing a guardianship that the facts support your petition, and don't randomly just be signing petitions because, that's what the person at the school told you to do. Evaluate the situation, talk to an attorney, and make sure you're making the right decision.
All right. So then there is this other protective arrangement under Article 5 of 11130, and it is part of the new statute. So we don't have a lot of long time with it to know how well it's going to work and what's going to happen. But basically, you can get a straight petition for a protective arrangement instead of asking for a guardianship or a conservatorship. It just has to be filed by someone who's interested in the person's welfare. A lot of the same standard as a guardianship or conservatorship petition, but it could be for a limited, just authorizing one or two duties instead of needing a guardianship or a conservatorship. Doing a guardianship or a conservatorship creates a lot of work for the court and for the families involved. And if you just need to do very minor things, it doesn't make sense to bring that burden to everybody. It's not necessary. It could also just be for specific actions, and then the protective arrangement could end. It shouldn't just be used because people don't want to do a guardianship or a conservatorship report. That's not the best use of it. But not everything has to go before a judge for approval when you're just acting on someone's behalf. And you also just don't, sometimes if there's big assets, you might need a bond or something. So you don't want to use it to avoid accountability for people. And I know that this one is tough. I think the big thing that comes up is, are there any examples? And so I've done two. I was a court visitor on a case, and there was a woman who was 30 years old. Ever since she was a child, she's been severely disabled. Nothing has changed. She's been a deaf mute. She does use a tablet to communicate, but she has limited language comprehension and expression. But when I met with her, I do feel like she understood enough to know that she wanted her family to help her. The reason that the guardianship petition had been filed is because the passport agency, the State Department, said that they needed Wendy to verbally ask for her passport, which is difficult if you're, say, mute. And they would not issue the passport without one. The family already had plane tickets to go because this had never been a problem before, and they had provided Wendy's passport on numerous occasions. I think the passport agent was wrong. However, that's a very slow process to challenge that, and the family was going to be out several $1,000s if we didn't get the guardianship and conservatorship. So I propose that we just do this other protective arrangement. The entire arrangement is that the mother can get the passport. And what we've asked for is that there is an annual accounting, because what some people thought is that we'll do the other protective arrangement and then dismiss the case. But if you dismiss the case, you don't have the order anymore. So you keep the case alive, but you typically just send in a report to the judge, and every judge will get to decide what it's going to be. But the judges I've worked with have allowed my clients to just send a quick email in and give an update, and then the protective arrangement continues. But this is literally for a passport application. I don't think that the court wants an update on every time she leaves the country.
This is just a side. I'm sorry about this, but
Yeah.
If anybody's interested about passports, this happened to me. I was ready to go to Europe, and the night before I looked, my passport expired. You can get a passport in one day.
Oh,
You can, and you go downtown Seattle with
Yeah.
everything
right.
that you have, and you're not guaranteed.
Mm-hmm.
And I was like, they gave them out. I think I was the last one almost. Maybe two other people waited. And I flew over to Europe, and the passport, the guy in Europe looked at, this passport was issued yesterday.
Yes. Yeah, which was helpful in this case because their trip was coming up. It was over the Thanksgiving holiday, so we had to hustle to get the passport. And luckily, the commissioner understood what we were trying to do and didn't have concerns. I was a little worried that it's like we're taking a vulnerable adult out of the country. How do we make sure that they're not being exploited or anything? So I was prepared for that argument, but it didn't come up. And she had a long history of traveling with her family. So
Could reject. Awesome.
yeah, so we just wanted to make sure that she was okay. It worked out, and so far she's just had to report in nominally on this matter, and they're not involved in the court system. We're not having to deal with attorney's fees or reports, and she seems to be doing really well. Another case I had is there was a family member cousin who was heavily involved with the vulnerable adult. Just showed up all the time, spent money out of his own pocket because his cousin was on disability benefits and there wasn't a lot of money, and he likes to eat pizza and go out. And so his cousin always took phone calls, was on the spot for doctor's appointments, clothing. His cousin never lacked anything. He did live in an adult family home, but he was very involved in his life. So he was already the guardian conservator. I got reappointed because he was not doing the annual reports in a timely fashion and not getting the paperwork in. So I had a hard time tracking him down. He did not always take my phone calls, and sometimes it would take weeks for him to get back to me. I went to the adult family home, and I was talking to the adult family home provider, like, we might have to look at someone else. And he's like, please don't replace him. He's so responsive. I'm like, responsive to who? Do I have the right number? And so I called him. He didn't answer. And I told the adult family homeowner, I said, call him on the phone right now. He picked up after 2 rings. And I think part of it, you could tell in his voice that he was busy and that we had interrupted him. But he was like, what's going on? Is everything okay? And so I had to think about this a little bit, like, do we really want to remove this person who's doing a great job at everything except the paperwork just because he doesn't have the bandwidth for it or doesn't understand the importance of it? And he was already the rep payee, so we didn't need the conservatorship, so we got rid of that. And really, he just has to make medical decisions and placement decisions and attend the DDA plans. There's already a DDA care plan in effect. So I don't know that the court is going to modify that care plan so significantly that they have to monitor it. And the person was already in an adult family home, so there was already a lot of oversight happening. DDAs coming in, doing their visits. What does the court add to that process in the family? So I did make a recommendation to the judge, and I you always want to be forthright with the court. Like, yeah, he is terrible at this paperwork and he is not responsive to us. However, he's responsive to his cousin, and I don't think we would have found anybody who was more dedicated to him. So the court agreed to use an OPA, and he has to file the DDA care plan every 3 years and send an email to the court just stating how the person is doing. And then they can decide to call him in or not. And his order says that he's permitted to make medical decisions, to attend the DDA appointments, things like that. And what's interesting about some of that is I know that the state agencies, accept the orders, but some of the federal agencies, like the U.S. government, don't have to accept our guardianship or conservatorship documents either. So it's nice to have the order, and it's nice that so far people are being flexible with it. And so I think that here's where we might talk about what are some of the drawbacks or differences when you're dealing with somebody who has maybe a developmental delay, and you look at something like a power of attorney. Just because somebody has capacity to execute one of the downsides could be you have maybe dueling family members. So every week they take the person to do a new power of attorney. So obviously now we have a situation where the power of attorney is not effective because it keeps getting changed. And so you could go guardianship or conservatorship, or you might look at another protective arrangement and make it so that no one can revoke the power of attorney except the court. And then they would have to make a decision about, did they have capacity to execute it? And do we have the right person in place making these decisions? I think one of the challenges that Jim and I face, because we do the guardianship conservator clinic at Tacoma Pro Bono, is that people don't understand the difference between a guardianship and a power of attorney. A lot of people think a guardianship or conservatorship gives them the ability to do things it doesn't. Like, yes, you can determine placement, but you can't make your child live with you forever just because that's your preference. If they want to leave the home, move out, or do something else, as their guardian, you should be helping them do that. Some people view guardianship and conservatorship as like extended parenting, and it's not. And I will tell them, you're going to get into more trouble with this fiduciary duty than if you just didn't have one. You can't take away somebody's rights just because you're a guardian or conservator. And even though they've lost certain rights, they still have other rights. They can date, they can hang out with their friends, they can make bad choices. It's not the protection that some people view it as.
Yeah, it's really heartbreaking having people come in and say stories. Oh, my son's living on the street because he's not taking his meds, and the answer there is not a guardianship, because the judge isn't going to come and force them to take their meds. The other thing, and I was kind of looking for the statute because I don't remember it right off the top of my head, but there is no question, if you dig through 11-130, it talks about you are trying to act how the individual would. You can't substitute your judgment for what the individual wants. So when I tell my stories, I try to be creative and include things in my own life. So let's just include things in my own life. I have a small dog. My mom hates dogs. So my mom could not file a guardianship against me saying I'm disabled to take my dog away because my dog is important. But that's an example of substitute judgment rather than what the party would want. I also think the real problem with powers of attorney is not being able to limit rights. One of the things that I struggle with, because we have a lot of substance abuse problems, is you can have a guardianship. Maybe you could do some sort of decision-making agreement that says I won't do drugs, or I'll call so-and-so before I do drugs. But you can't do a guardianship that basically says don't do drugs, because that's not enforceable. That's not something that works appropriately in the situation. You could probably there are some mental health directives that can be done. There's some other things that can be done. There are some other tools, though, but this is not really what the guardianship was created for. I get a little frustrated. To me, that even the new modifications to the law, this looks a lot more like it's conceptually there to think about elderly people who are losing capacity over time, and less so for people who are born with delays. My concerns with power of attorney always are, how do we control bad choices that the party may make? Because a power of attorney, as I think I said before, is supplemental. It is not revocation of rights. What I have done in a few of them is we've done very limited guardianships to revoke certain rights, or give somebody some additional help. If they can't make medical decisions, then the guardian will step in. I will be intrigued to see how those work. But I think we have a group of the population that you're not going to be able to make better, whatever that is, just by doing a guardianship or conservatorship. You're not going to make them take their meds. You're not going to get them to stop living on the street. You're not going to get them from going to certain websites. You are not going to put them in a position that they can't talk to certain people. There is some language in 11130 about controlling who has access to it. I'll be intrigued to see what Ms. Johnson says, but I struggle quite a bit because I think that we really can't revoke people's rights in a guardianship to associate with who they want, except in exceedingly high bars of danger. You can't just say, oh, every time they go out with so-and-so, they get drunk. Okay, we're going to revoke so-and-so. I don't think that's an acceptable use of the guardianship. So, yeah, your thoughts?
I don't think so either. In general, if we're revoking contact with somebody, I think we're looking at a VAPO or a VAPO. Like, I don't know that we're doing it. There is a limited way you can restrict someone for a time limited based on the circumstances, but that's a little more challenging. And again, this, when I'm going through the guardianship and power of attorney with people, I don't ask them what they want. I say, what are you trying to accomplish with this document? And then that way I can say, oh, you can do that under a power of attorney and a guardianship, or, oh, you can't do that under either of those. Because some people do think that guardianship is much more powerful than it is.
Right. And I love, and this is me complaining about our financial service industry, you walk in with a guardianship order and a power of attorney at the same time. They're going to look at you like you're trying to do something weird with the guardianship order, but they'll take that power of attorney. They don't care who drafted it, where it came from, it came off the internet. But apparently that court order is immediately suspect. And I have actually had bankers tell my clients, this order means nothing. You need to go do a power of attorney. And I'm like, well, you should read 11130 and learn the law.
My favorite, though, is when the order revokes the right to make a power of attorney.
Absolutely. And then they say, and the banker tells you need a power of attorney. It's just an interesting situation of giving everybody their right to make their own decisions. And I think Washington is pretty clear. We're a state where we value freedom over control to an extent, at least by statute. And one of the things that's important to me is that we give people the ability to screw up, because this is not wrap somebody in bubble wrap. And I see that especially with the 18-year-olds with disabilities, that the parents want to wrap them in bubble wrap, keep them safe from everything they possibly can, rather than letting them fail at a few things. And I think we need to be more creative. Like, the whole idea of freezing credit and a power of attorney was something I never thought about, other than thinking about a young person who is going to go probably sign up for things because they don't know any better. My question, and I'll throw this out there, is if you have a child who goes to McDonald's, buys their, well, I was going to say $5 burger, but I don't know if those exist anymore, their $20 burger, and they give them a $50 and the person doesn't give the money back, does that rise enough to need a guardianship? Because they are not taking good care of their finances, probably, but that's an interesting question there, is that if that person has a disability, is that enough danger?
Well, let me ask you a question. What would the guardianship do differently? Are you then going to not give them, because they
you're not going to
home spending money?
Right, and that's my issue. Is there's only so much we can protect people in a guardianship situation, and you can't make everybody safe all the time. The other big concern I have with power of attorneys as a lesser restrictive alternative, and this is maybe where the irrevocable power of attorney is great, or having something in a court order that says this is the power of attorney, you can't change it without coming to court, is a different family member gets involved and says, oh, now I'm the power of attorney, now I'm the power of attorney. And I see that mostly with elderly, where all the kids are helping themselves to mom and dad's estate using the power of attorney, and they are constantly using different powers of attorney to do different things that benefit them. One thing that we haven't really talked a lot about, but since we're talking about powers of attorney, when you are operating as a power of attorney, you do have a fiduciary relationship, but you have a second relationship. You now have what's called a confidential relationship. So if you do help yourself to some money and it ends up in court, actually now the burden is on you because of the confidential relationship to show you didn't rip off the estate. And one of the things that happens in guardianships all the time is I hear, yeah, but I put the money back. No, this is not your money. You don't get to use it for a few months. It's not an interest-free loan. You can't use your child's money and then put it back. That is not okay. This is your fiduciary. You are reporting to the court, and the court will not do well when you are saying, yeah, but I only used that $10,000 for a few weeks. They're not going to be happy about that. The other thing with reporting is you're required to report yearly, or mostly in Pierce County, it's yearly or triannually. The forms do say every 2 years. Have you ever had an every 2 year one at all? I've never seen one that way, where you have to report, and you've got to report. These are difficult reports, and you've got to be good. And if you don't do it well, the court will remove you. As the case with Sam we talked about earlier, that was a good solution to a problem. But I get a lot of court visitor appointments where the guardian has just stopped filing reports, disappeared. They no longer have an attorney who knows where they are and what they're doing. And that's a big fear as well. It's not always, everything isn't always protected, even if you've got a guardian in place. And we do a lot of court visitor work on those situations where people just aren't following up with the court. That is why I like when you've got somebody with minimal assets, rep payee and done, no need for an accounting. Now, Social Security in theory is going to ask for an accounting. They don't always do that, but you do have that. And I have one right now, and I'm trying to figure out how to advise the client. Is they're getting a lot of blowback from a certain facility that you need to put in control over their social media. And I'm like, I don't see how that can be in a guardianship order. There's no ability to say you get an hour of screen time in your guardianship. Maybe we could do another protective arrangement or something, but that's not really what the court's looking at. And I don't really understand why that's such a big deal. Like, enforce the screen time or take their phone away. That's not really what the guardianship is for.
Go ahead.
Well, in terms of, I'm kind of interested in creditors, with respect to creditors and issues about assets like real estate, or a creditor on a credit card that the person does. Is there any case law with respect to the public notice aspect of a guardianship? In other words, it's a recorded document.
It's not a recorded document, but it's a public court order.
It's
Absolutely
public
right.
So
Right. Yeah, it's a public record.
You don't have any case law where creditors are restricted from suing if there's a guardianship?
Well, one of the rights that can be revoked is your right to be sued or sue, but through the guardian.
Okay.
So
through the guardian.
Right. So what should happen? And let's say we've got somebody who's got a full conservatorship, full guardianship, and they have had that right revoked. Then any lawsuit should be brought against the guardian/conservator. I would say it should be brought against the conservator, but if I was doing it, I'd probably do both. That is something that a lot of people in the creditor world do not understand. They will bring actions against somebody who they don't have a right to sue.
Right.
And I once had one of those kicked because I'm like, you can't sue this person. We have a court order that says you can't be sued, but through the guardian. There's no guardian being sued here. You sued the individual. So that is something I've seen. There's nothing like in probate where you have notice requirements, but on your guardianship plan and your guardianship report, you're supposed to lay out what debts are there, what the monthly payment is, all those kind of things, so that the court knows. Like, say you've got somebody who lives in a house and they've got a mortgage on it. You disclose there's a mortgage with ABC Bank. The payment is, $400 a month.
Somebody who might own real estate in other counties, I think it might be wise to file a certified copy in the county where the real estate is owned.
Or to put the real estate into a trust or something, because you're not necessarily going to leave it in that person's name to transact, depending on if they still have the right to do the real property.
I had a situation where an older gentleman was able to be convinced to take a trip up to North Seattle or Everett and buy a $10,000 Hummer. He had perfect credit. And he didn't have a guardianship.
Yeah.
And that was a mess because these folks who did it went to California and did a home invasion. Car was gone. They were real con artists.
Which could happen to anybody, though. It does happen to vulnerable adults, but many people have been scammed with fake money or other things. A guardianship is not going to make people be better people.
Right.
I read a story out of California because, well, if it's not out of California, it's out of Florida, where a real estate agent took a woman to Applebee's. They had some cocktails, I think they were margaritas, and then signed her house over to this real estate agent.
Oh.
I bet that person had some diminished capacity, but she also had some alcohol on board, signed away $1 million house, and then the real estate agent kicked her out and sold the house and made a whole lot of money.
No, I would imagine, like in Washington, you probably couldn't get criminal charges filed because they just.
So in this case, there were criminal charges. I know that, and I think there should be. I don't know if there would be. That's the real question, but. That shows, and I've never met this woman, but that shows even somebody who is a little bit older, who's too trustworthy, may not even qualify for a guardianship, but will make bad decisions. The big thing I like to say is until the court determines you lack capacity, the statute is very clear you have capacity. So you can cause a lot of trouble in your own life. And that's why, I tried, maybe I sounded like I was dissuading people from filing guardianships. Just be comfortable that you can stand up in court and defend your position. Mm-hmm. And I don't think an 18-year-old is turning 18, and therefore we need a guardianship just because they have autism is a defensible position. I think a different position of, so I'll talk about one that I had. I was a court visitor on this one. I think you were a petitioner. And the woman seemed to have capacity. Then I found, then she also had a situation where a banker ripped her off a bunch of money. And then I called APS to find out about that case. And then it became pretty clear that every person in this woman's life was trying to get her money because she had a ton of money, like a crazy amount of money sitting in a checking account. And I think everybody in her life was taking advantage of her to the extent that she said, no, I don't even need a guardianship. I've got brothers. They're coming from the East Coast. They're going to help me out. And I don't know if those people existed. I don't know if that was a scammer. Like, I have no idea what happened with that story because she couldn't tell me who they were, where she found out about them. So we do have people who appear to have capacity who sometimes don't. I think we have people who appear not to have capacity and sometimes do. And I think it's very hard to look at what you're doing. I have a friend who does a lot of Alzheimer's research, and he is a neurologist. And he was talking about somebody came in to his office and was talking about playing tennis the day before, and he didn't think anything of it. And then he was talking to the family. Yeah, he hasn't played tennis since high school. So that person was operating in a completely different world, but that sounded completely believable because any of us could have been playing tennis yesterday. It's not something that sounds outrageous. Whereas if you come in and say, yeah, I went to the moon yesterday, where it's going to be pretty obvious we've got some problems there. So I think it's
anymore with those.
Well, that's a good. Well, I still don't think any of them have landed on the moon. And I think it's just a case of trying to determine what's best for the individual. And one of the things to backtrack a little bit with powers of attorney, I struggle that a lot of attorneys see powers of attorney as just an add-on thing we do when we're doing the will. In many ways, I think a power of attorney is the most powerful document because really, what are you doing with a will? You're leaving your stuff to people when you die. You're not here. Who cares, With a power of attorney, you're giving that person basically complete control over your life, and you need to be really thoughtful of what you do that for. I once had somebody, so for 100 years when I did presentations like this, and if I'm talking about power of attorneys, I would say, oh yeah, mom named her daughter went to the casino down the street, gambled all her money away, and now mom's out of luck. Well, I got that call one day, and the call was not what happened. It was mom calls up and says, so my daughter closed my bank accounts with my power of attorney. And I'm like, yep, that's terrible. There's not much we can do. Where's the money? And she's like, oh, she's already spent it. And then she floored me with this. I never really trusted her anyway. And I'm like, then why did you name her power of attorney? Like, be thoughtful who you're naming as power of attorney. I also think there probably should be looking at who has the right skills. Now I'm going to throw myself under the bus. On my mom's documents, I am her financial power of attorney. I'm the lawyer. I understand finances. I understand money. But my brother is her healthcare power of attorney for two reasons. One, he's a drug dealer. Okay, really pharmacist, but close enough. But two, he understands medical stuff. And if I hear medical stuff, it sounds like Charlie Brown voice. Wah, 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 and I tune out pretty quickly. So it's also a good idea to look where people's skill sets fit because not everybody has the skills to do everything. And make sure you're picking the right child. Don't just name your eldest or your youngest as your power of attorney. Have the person who can do the job. And the other thing with power of attorney is think about the powers you are granting. One of the things I actually do, and I don't know if this is a good or bad or indifferent idea, but if I've got somebody who has diminished capacity, I may pull out some of the end of life stuff and some of the living will items or advanced healthcare directive is what we're out of the document, simply because I'm not 100% sure they really understand that well enough to make that decision. They understand that they might want mom to make decisions about their health or take care of them if they're sick, but they probably do not understand what is end of life and all that kind of stuff. I know my daughter asked me a lot of questions about it, mostly about my dog that died, and it's hard to explain. It's hard to know if you should lie or tell the truth. Because part of me wants to lie to her so she doesn't have to worry about death, and part of me wants to tell the truth, but then she'll get even more sad. And probably her mom won't be real happy with me either. So it's really hard. You have to have a hard look at what you're granting this person. One of the things I flat out do is if I am doing a power of attorney for somebody with diminished capacity, especially somebody with minimal assets, I usually take all gifting authority out of the power of attorney. Because we may want it for Medicaid purposes, and again, case by case. But I always worry when I have somebody with lesser capacity, do they really understand Medicaid gifting? Do I really understand Medicaid gifting? If we want to draw it out far enough. So I think what we need to always be considerate of is what is their understanding level and what are we giving them? There's a big difference if I want mommy to help me manage my money to, I want when I'm sick, if I can qualify to give assets away to my family. They probably don't understand that. And I do meet a lot of children with autism or adults with autism who don't really understand money at all. It's worth about as much to them as this piece of paper. I remember trying to take my daughter to the bank when she got a check from my mom. So we'll take this, we'll go to the bank, you'll get cash, then we'll go to the store and buy stuffed animals. And that didn't work at all. That didn't work. She just wanted to buy the stuffed animals. She didn't understand you have a $50 budget. Like none of this stuff worked. It was, I want those ones. And there's $60. Well, you don't have enough $60. And finally I kick in $10 more because I don't want to have a meltdown over stuffed animals. But you've got to consider what their ability is. I think you've got to be thoughtful that this is not a typically developing individual. So we're not just going to force anything. But I think even for your typical individual, you should be going through your power of attorney and what it says and make sure they're on board with that. The biggest problem I've seen with that has to do with Jehovah's Witness and their healthcare power of attorney and their blood stuff. But I kind of go through everything. Are you okay with this power? Do you have a problem with this power? Do you understand what this says? In all my powers of attorney.
Jim, sorry to ask another question. What I've done sometimes, and what do you think about having co-powers of attorney and a power of attorney says both must join in the act? Now that would be for they'd have to be together at the bank.
Right. That's to me the biggest problem with that is they may both need to transact all business.
Yes.
I've also written powers of attorney that way that the bank has let one of them sign, which just blows my mind.
Even if you say the joint signature will
absolutely. You think they read the power of attorney?
Well, you do it when you argue about it, I guess.
Right. And
America don't try that.
Yeah. So no, I had a situation once, and that's flat out what it says. It said both parties had to act. It was joint liability. Nobody could sign without both signatures.
Yeah.
And the bank said this power of attorney is invalid because we only act on one signature. And I'm like, so you're just making up stuff that's not real.
Yeah. Maybe ask them to call their corporate attorney. And
right.
Well,
and that's the real frustrating problem is you never can. The bankers make stuff up and just say what they want. You can't talk to their legal department, and I'm not even convinced that the legal department even understands this as granularly as those of us who are doing it on the ground.
California, and you call there, and they're like, we don't watch it.
Well, I pick on, so I used to practice law in Ohio, and Key Bank was my nemesis, and I thought moving out here I'd never need to deal with them again. And they still continue to, there are things I can flat out tell your Ohio law they're applying.
Their bank stuff. Okay.
Yeah, and I don't pay any attention to it, but it's really, really hard sometimes that power of attorneys, I think, are just kind of a throw-in thing. I think you should make a big deal about them. I have now put some language, and Ms. Johnson is pulling it up here. It is, where'd she go?
You say refusal to accept
the power of attorney. I've now actually put that right under my power of attorney. If you refuse to accept, this statute applies, and we're going to come after you. And I stole that from somebody else, and I have it in bold. like right under, I appoint Liz Johnson as my power of attorney. If Liz can't do it, then I appoint X. And then I put some language in there: refusal to accept this power of attorney is we're going to sue your butt under this. And that's
there is a process to reject the power of attorney. So I have it in mind as well. And I will usually just send this over to the bank and I send them the exact statute, because if you don't want to accept the power of attorney, the big thing people come to me for is they're like, the bank says you need to rewrite it. Will they be writing me a check for that, or they want you to pay for that? Perfect. But so I send this back to the bank, and it says, you can request a certification or a translation, but you have 7 business days. You don't get to make that decision 2 months into this argument and say, I don't like it. If they do request it, then they have to accept it within 5 business days of receipt of it. They do not get to, and it says very specifically, you cannot require an additional or different form of power of attorney for the authority granted in it. And so once I started sending this over with a letter, I have not had a problem with banks accepting my power of attorney and following them, mostly because of this. So if you don't do it, if you don't follow these rules, then you can be responsible for these, and let's hang out in court sometime. Right. So this has been very helpful to deal with that, because I would get a lot more calls about it and a lot more family issues about it until I started faxing that over.
Now, to kind of really switch subject here, one of the things I like to rant about is the statutes I'm going to put up next. One of the reasons I hear a lot of people feel that they need a power of attorney is to make healthcare decisions.
Oh, wait.
It's not being shared.
Oh, okay.
I will do it.
Okay, so I'm talking about RCW 770065. Write that down. That is the informed consent law that says, if you read it, individuals who cannot consent, and then there's a list of people who can make decisions. So number 1's the guardian, number 2 is the power of attorney, number 3 would be the spouse, number 4 would be children who are over age 18. So in theory, we already have a law that says, if you do not have capacity to make decisions, here's who can make decisions. My experience has been many facilities ignore this completely. They don't care what it says. They don't care that it's law. They just say you need a guardianship. Where I am running into a lot of my problems in those situations actually is the insurance company. When the parents' insurance is involved, they struggle and say, oh, no, we can't talk to you, even though you're paying for the insurance, even though the child is not a minor anymore, or you've got to do X, Y, and Z. But this informed consent law is something I give all my clients to say, keep this in your wallet and pull it out. Anybody tells you you can't make healthcare decisions for your child, because it flat out says that. And I am pretty sure the RCWs are the laws of our state. What I have been given a little blowback is, well, HIPAA overrides this, and I'm not going to get into a constitutional law question of what controls. But we have a state law that says who can make a decision, and they're willy-nilly ignoring it. Now, the problem is, if we go to the bottom of this law, there is nothing in here to enforce it that I have seen. It's not like the power of attorney rule. I wish there was something in there that if they don't do this, I could get attorney fees. But that's something that I tell everybody with children with disabilities: carry that with you and throw that out and say, okay, why aren't you honoring this Washington law? And I don't ever get good answers to that.
What's the standard of proof doesn't have capacity? It's like, is it based upon the person saying it? They don't have capacity.
Right.
That would be, I could see a hospital tell, I'm not going to say anything.
Right.
I mean, no. They don't.
Yep, I can see your issue, but I'm also saying this should work for a parent who doesn't have guardianship.
Okay. And I think we're going to open it up for questions. Amy, is that what you were?
Right. We'll open this up for questions. So please put your questions in the chat, or just unmute yourself.
Good afternoon, Steve DeDavo here. I appreciate your presentation. When it comes to interstate banks and medical providers, I mean, they've all but told me we don't have to comply with state law. We're a federal institution. And they basically say, we're not going to comply with your orders. You're not going to comply with your POA. And essentially, go ahead, take us to court for contempt of the Superior Court order directing them to do X, Y, and Z. And that gets really cost prohibitive. Most of my clients are not well heeled enough to deal with those kinds of issues.
Right. So I think that has two issues. I think that if you have a bank that practices who operates in Washington like Key Bank, I don't see they have any ability to say we don't honor state court orders. I think it's a really interesting question, and one that I'm dealing with now is I have an individual who is under guardianship in Washington, and a Montana credit union refuses to accept our order and say, well, you need to get a Montana guardianship. My response to them is explain to me how somebody who lives in Washington has jurisdiction to go get a Montana guardianship, and they don't seem to care. So I do wonder how we deal with that. We do have this full faith and credit clause that I thought applied, but maybe I read a different constitution than other lawyers. But to me, I don't understand how full faith and credit doesn't apply here. I also don't understand, if you're doing business in Washington, how you can deal with this. I tell a story sometimes. When I practiced in Ohio, I practiced in a somewhat smallish county south of Cleveland. And I was once at the court, and I was just kind of whining to the clerk about the bank would not honor the guardianship document. And the judge overheard, and he comes out and he said, well, Mr. Bates, do you have a few minutes? Let's make some phone calls. And he calls the bank and said, so what vice president is going to be here for contempt of court on Monday? And I think our problem is exactly what you said, is you could go to court and you could go spend time in Superior Court, hang out and fight about this. But our clients don't have the money, and that's what's hard. Now, I have never had a bank say they wouldn't accept a power of attorney. Usually the only time they won't do that is we need it on our form, which, of course, the statute says isn't okay. Like, it's flat out in the statute. But I've never had one not accept a power of attorney. But, yeah, this whole thing of not accepting state court orders blows my mind, and I wish I knew somebody who was more of a constitutional scholar who could explain why doesn't this apply? Like, what's going on here and how do we make that work? Do you have any input to this at all?
I don't generally have a problem. I usually call over and talk to the institution. If they're in Washington, I'm like, you came to Washington to do business, so thank you for accepting our laws. If it's in another state, I usually can just call over and talk to somebody and get what we need.
Yeah, my problem has been, well, I'll tell you a funny story that's totally not on the topic of guardianship. This was a trust. Is you see a lot of revocable trusts that are called, the Bates Family Trust. I once had Key Bank tell me that anything that's a family trust is irrevocable. And I said, that's really impressive. You can decide that based on the name, and you don't even look at what the terms of the document say. And I like to say kind of Ohio's a little bit backward, but in this case, it flat out was in the law. The trust is revocable unless it says irrevocable by terms, but Key Bank just decided because it said family. And my experience, and maybe Liz is just nicer than me, I can't get them to call me back. That's my real frustration, is you can't get anybody in the legal department to call you at all. Maybe you're just nicer, so they call you.
Fax the statute and consequences first.
That's not a bad idea, too. I like that idea. If you fax them and say, maybe we want to have a chat. But I do wish that going to court was more affordable or easier, or our clients had the money to do it, because I think there are a lot of things in these areas of law that don't get litigated or dealt with because just nobody has the money to fight them. And the cost of litigating this stuff could be tens, if not hundreds of thousands of dollars. So we'll just give the bank what they want rather than fighting about it.
Do we have any other questions? Nope. Okay.
I have one more. And I'll add on here that I have had a little luck, and Key Bank happens to be the one of them. I have sent everything to General Counsel in Cleveland after looking everything up on the annual report, and he gave it to his secretary, and we got a response because we could not get one locally. So we have resolved issues with General Counsel. The other issue I have is I'm backtracking on you in that we're talking about the threshold question here, and whether we have capacity or not, or incompetency related to a guardianship or a conservatorship. I get people in my office. The question is, I know I've got some capacity issue, and now it's really for the two of you. Do you guys take consultations or evaluations, because you do this all the time, I don't want to file that guardianship or conservatorship, yet I think some action needs to be taken. And now you're telling me that it's possible, if I've got that wrong, that I could be paying all the fees for bringing that petition before the court.
So I think that becomes a tricky one because you do have to do due diligence. But if you start interviewing the person who's subject to guardianship or conservatorship, who is your client, I mean, when you're filing any other kind of lawsuit, you don't get to go talk to the other side first to hear them out to see if your client has told you everything accurately. So I will usually talk to whoever the petitioner is going to be. And then I will send them to an attorney I trust to do the capacity. I will send the person we're going to file against. I will see if they will go meet with another attorney, even Tacoma pro bono attorneys, to see if we can get to capacity. But I won't typically interview the respondent directly.
Okay.
I think it depends what hat you're wearing at that point and who you represent. One thing you may want to take a look at, and this is something that I just learned about, is if you go, I think it's the American Psychological Association, they and the American Bar Association have a handbook assessment of older adults with diminished capacity, and it's a downloadable thing. I think I got it off the American Psychological Association website and not the ABA, but I think it's a 100-page PDF that's got some nice stuff as well. I think to answer your question, I would probably, if it's questionable, what I usually get really irritated about is when the party hasn't done any due diligence and just files the guardianship. I think if you have somebody who you have met with and you're like, I don't know, I think the guardianship is the way to go. I don't think you are bringing that in appropriately. I think a lot depends on the circumstances, and kind of the way I look at it is, am I willing to stand up in front of a judge and defending what I'm filing? And if I'm willing to do that, usually I'm pretty comfortable. If it's on the edge and there's something gnawing at me, then at that point, maybe I need to reevaluate. I think that as attorneys, we all have a different view of what constitutes capacity for legal documents, and yours and mine might be slightly different. And I will also admit that there's a slight sliding scale in a situation, depending on the circumstances. So if you've got somebody coming in, and let's talk about elders. You've got somebody coming in who, wife of 50 years is bringing him in. They want to do mutual powers of attorney. I might be more willing to do that when it's the brand new wife who wants to do power of attorneys while cutting out the will and cutting out all the kids. So I think it depends on the circumstances. I think it's also when you've got a child, when it's the parents and they've been caring for them and they're full-time caregiver, that's way different than, some dude they met 5 minutes ago. So I think I kind of look at that too. What is the abuse? What is the potential for harm here? If we go too far, what can happen here? And honestly, when you're dealing with children with autism, they don't have any money, so I'm less concerned about them getting ripped off. I'm more concerned about them getting the care they need. And I think it just depends on the circumstances, because I have absolutely done powers of attorney where I've held the husband and wife of 50 years coming in. Okay, we'll do this, no problem. When it's the brand new wife and we're doing all these things, I'm holding them to a way higher standard for wanting them to understand. And in that case, I might not represent the couple. And I've absolutely seen that happen too, where people have come into me, we got married last week. I want to change everything. I want to make my new spouse. And I had met the guy a few weeks ago and didn't think he had capacity then. And now magically wants to change his estate planning. So I think it just depends on the circumstances. We all need to keep our malpractice carriers happy. And we all need to use our best judgment. And I think we all kind of have different standards, because I am much more willing to push it with a child who can sort of tell me, I want mom to make decisions. I did one actually Tacoma pro bono with another attorney, and he couldn't sign, but he could put his fingerprint on there, and that's how we executed the power of attorney. And he was very clear, he wanted mom to make help him with his healthcare. So.
Well, and it's always, I see a handful of times that either attorneys will do like an online capacity test and just, you're probably not authorized to administer those if you're not licensed to do it. I wouldn't do that. Or they will ask a client to go get a letter from their doctor certifying they have capacity. But capacity is a legal decision, not a medical decision. So it's not that I wouldn't consider that if it was brought to me, but I'm not sure I have the right to ask my client to go get a medical capacity assessment to determine if they have legal capacity. So when I'm doing my full intake, I'm trying to find out, have they signed other powers of attorney? Is this something they do every week with new attorneys? what are the players? Is there a lot of high family conflict? And then where are we at? And do they have the capacity to execute it, or even a portion of a power of attorney? Like Jim says, we're attorneys. We shouldn't be using forms. Everyone probably has a template that they start with, but you should be modifying each and every one. They can download a form off the internet. So
there's something you said there I wanted to expand on, but it's.
I mean, it was all brilliant, so it's going to be
yeah,
tough to.
Yeah, you're fine. It's fine. Yeah, and I am a big fan, and I have been a big fan of saying this for a long time. You shouldn't just be executing standard powers of attorney. I also, it's funny when we under capacity. Do they understand what they're signing? I'd love to know how many of our clients understand some of the documents they're signing all the times, especially when we do like Q-tip, credit shelter, trusts, and stuff. Like, do any of our clients really understand what they're signing other than the very basics? And that's kind of something that just floats around in my head as well. Is what does if you have a client who's maybe not so bright, should you change what you're doing as opposed to somebody who's a PhD? I'm still trying to think what I wanted to say. I don't remember. But yeah, I think we need to, as a bar, be better about our powers of attorney. Oh, I know what I was going to say. I think if we represent somebody, telling them to go get a medical thing isn't the best choice, because if it comes back very bad and you thought they had capacity, you now probably can't rule otherwise as part of your decision. So I think that could be a problem.
I disagree. I don't think a doctor gets to determine legal capacity.
Right, but are you going to be more nervous standing up in court when a doctor said yesterday they lacked any capacity, you signed the document the next day? That makes me nervous, again, going back into court in the future. I would rather just not have that evidence and be able to stand. I sat down with them. I made the legal decision. It's not a doctor decision. It's an attorney legal decision. Well, what about this doctor decision yesterday? Well, I never saw that before. I'd much rather not have that information.
Well, are you talking about guardianship?
No, I'm talking about anybody, attorneys who send people to go get some sort of capacity evaluation before the planning. Because my concern is what happens if it comes back really, really, really bad. We were on the guardianship board meeting last Friday, and everybody was talking about the slums test and all these crazy tests. I don't trust that I should be determining capacity. Quite honestly, I'm scared to take them because maybe I don't have capacity. Remember 3 words. Well, if they're not RCW and random numbers, I doubt I'll remember them in the next 10 minutes. So I do worry about that. I notice there's 100 million of them, and they're all, the one we were talking about was Ohio State. Like, I'm sure these are great tools, but I'm really leery of anything, and I know I don't have the ability to administer them and have a good thing. I just want to have a discussion with my client. The big question I ask is, you go visit somebody in the hospital, and they kind of know what they're doing, but they can't tell you what day of the week it is. And I really, really wonder, does that hurt us or not? Because if you locked me in a hospital for 6 months, I might lose track of days.
I don't ask that question. I was at a will signing, and we asked the person, what's today's date? And she didn't know. Mm-hmm. So then the attorney's like, then she looked at me, she's like, what's today? I'm like, Thursday? Yeah. Like, I don't know if the date is the best capacity question.
Right, but I'm just saying, I do question when you say what's today's date, what day of the week it is. I'm not asking the date, and they can't say Wednesday. But then I can also see if you've been in Tacoma General for a few days or a few weeks, you lose track of time. I joke since COVID, I can't tell it was 5 years ago, it was 3 years ago, it was 8 years ago. At this point, maybe that's just getting old. So I think we need to be really thoughtful about what questions we're asking, and I think we need to be somewhat a little more probative than we probably are. And I think we just need to be thoughtful on how we approach these. And I'm always thinking, what am I going to have to defend in court? And I know what I'm willing to do and what I'm not willing to do. And I think about that a lot.
Okay, so if there's any more questions, please now is the time to go. However, if you have not yet given me this room from the bottom of the state, otherwise, I'm going to let everybody see what awesome stuff. And then if you need any more additional information, please email me.
Okay. Well, thank you for
Thank you.
your questions and letting us come out today. Everyone have a good afternoon.
Yes.
Thanks, everybody.